My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please reach out to our channel and subscribe to that channel. We have a lot of times the question about how assets in the divorce are going to be divided. Many times somebody will think, well, since I work, I bought the house, I contributed to our savings, I contributed all the money to the 401k plan, therefore I get to keep it. Or sometimes it's the other way around. The other person will call and say, my ex did this and that. Does that mean I don't get anything? Well, the answer is it doesn't exactly work that way. Okay? The court first looks at what is marital property. Marital property, in its simplest definition, is property accumulated during the marriage. So if people are married, one goes to work and makes money. One is able to go to work to make money because the other person is at home taking care of the house and the kids. So if that marriage falls apart, there's going to be a division. There's going to be a division of those assets that recognizes the equal value of the person making the money and the person enabling the making of that money by taking care of the house and the kids and the other contributions. So when we talk about one person was the breadwinner, does that mean the other person's out cold? That's not how our laws work. If you think that that is going to happen, divorce court will prove to be a very rude awakening because it's not how it's going to go. The court's going to look at when was this accumulated. Now, let's say part of the asset was accumulated before the marriage, like you had a house, you bought it before the marriage. Then you meet somebody, you get married, you move into that house, and now we got to divide it because we're getting divorced. Well, the answer to that mathematical calculation is like this. The court's going to do that calculation, look at that house, and see what was the value of that house on the day of the marriage. If the value of that house was $200,000 on the day of the marriage, that $200,000 belonged to the guy who bought it way back when. As of the day of the marriage forward, what is the degree to which the house went up in value? If it went up $50,000, then that 50 would be in play. So the 200 would be off the table, but that 50 of increase would be divided 25 apiece. In this same scenario, therefore, the values would go, one would get 225 and one would get 25. Now, of course, there are exceptions. Suppose the person granted the house, wrote a deed, gave it to the marriage, now it belongs to everybody. They've lived in it as the marital home and all that, and things can change that might alter the fairness and the equity of that mathematical calculation, but that's generally the basics. So therefore, my point is this. Just because you were the one who caused the bank account to fill up from your labor does not mean that that will not be split. And just because the house is in someone else's name, that doesn't necessarily mean there won't be a division either. It's going to be on a case-by-case basis, and the first thing the court is going to ask, when was that asset accumulated? If you have any questions about that, reach out. We'll be glad to help you out.